They sued me for $50. Over my rescue dog's occasional barking, claiming it violated some obscure noise ordinance that apparently only applied to my property. What they didn't know was that I'd spent 15 years as a paralegal specializing in property law, and their lawsuit was about to uncover the biggest HOA fraud scheme our county had ever seen. Sometimes the best defense is discovering your accusers have been breaking laws you didn't even know existed. My name is Rebecca Chen, and 6 months ago, I thought moving to Willowbrook Meadows would be the fresh start I needed after my divorce. At 42, I was ready for a quieter life where the biggest drama would be deciding between morning coffee on the front porch or the back deck. I'd spent the last 15 years working as a senior paralegal at Morrison & Associates, specializing in property disputes and municipal law. Before taking early retirement with my divorce settlement, the plan was simple: buy a nice house in a quiet suburban community, maybe get a dog for companionship, and finally have time to read books that weren't legal briefs. Willowbrook Meadows seemed perfect when I toured it last fall. 43 homes arranged in a horseshoe pattern around a small man-made lake, with well-maintained lawns and mature oak trees that reminded me of the neighborhood where I grew up. The HOA fees were reasonable at $150 per month, and the woman showing me around, Linda Patterson, assured me it was a peaceful community where neighbors looked out for each other without being intrusive. The house I bought, 1,247 Maple Lane, had a fenced backyard, perfect for a dog and enough space for the home office I planned to set up for occasional freelance legal research. 2 weeks after moving in, I adopted Copper, a 3-year-old golden retriever mix from the county shelter. He'd been surrendered by a family who couldn't keep him when they moved to an apartment. And something about his gentle brown eyes and the way he rested his head on my lap during our first meeting told me we were meant to be together. Copper was well-trained, friendly with people and other dogs, and seemed to understand that his barking should be reserved for actual reasons like strangers at the door or the occasional raccoon raiding garbage cans. For the first 3 months, everything was exactly what I'd hoped for. Copper and I established a routine of morning walks around the lake, over afternoon work sessions in my home office, while he napped in a patch of sunlight, an evening relaxation on the back deck overlooking my small garden. Several neighbors introduced themselves during our walks, including elderly couple Martha and George Wilson, who lived 2 houses down and always had treats for Copper, and Sandra Kim, a working mother of 2 who appreciated that Copper was gentle with her young children. The problem started when Derek Hoffman moved into the house directly across from mine in early March. Derek was 38 years old, recently divorced, and apparently dealing with his life changes by appointing himself as the unofficial neighborhood watchdog. Within a week of moving in, he'd introduced himself to me by complaining that Copper's morning barking was disturbing his sleep. This was puzzling because Copper rarely barked in the mornings, and when he did, it was usually a brief alert about something specific rather than sustained noise. Derek was about 6 feet tall, with prematurely graying hair that he kept meticulously styled, and he dressed like he was always headed to a business meeting, even when he was just checking his mailbox. He worked in pharmaceutical sales, which he mentioned frequently, along with comments about his experience dealing with difficult clients and complex regulations. Everything about Derek suggested someone who was used to controlling situations through persistence and professional intimidation, and he clearly viewed Copper's occasional barking as a problem that needed to be managed rather than understood. I tried to be neighborly by explaining that Copper was well-trained and only barked when there was something worth barking about, usually for less than 30 seconds at a time. I offered to work with Derek to identify specific situations that might be causing problems and to adjust Copper's routine if needed. But Derek wasn't interested in solutions that involved cooperation or compromise. He wanted the barking stopped completely, immediately. and he made it clear that he viewed this as a simple matter of enforcing community standards, rather than finding ways for neighbors to coexist peacefully. Our first real confrontation came on a Saturday morning in mid-March, when Copper barked briefly at a delivery truck that had pulled into our driveway. I was signing for a package when Derek stormed across the street wearing khaki pants and a polo shirt, carrying a clipboard, and wearing the expression of someone who'd been waiting for exactly this opportunity to make his point. "This is exactly what I'm talking about," Derek announced, gesturing dramatically toward Copper, who had already stopped barking and was sitting calmly beside me. "It's 9:30 in the morning, and that dog is creating a public disturbance. This is a residential neighborhood, not a farm, and some of us value peace and quiet." I looked at Derek, then at the delivery driver who was watching this exchange with obvious bewilderment, then back at Derek. He barked for maybe 10 seconds because someone pulled into our driveway. That's normal dog behavior, and it's well within reasonable noise levels for a Saturday morning. Derek's response revealed something important about his personality and his approach to conflict resolution. Instead of acknowledging that different people might have different definitions of reasonable noise levels, or that compromise might be possible, he pulled out his clipboard and started writing something down while speaking in the tone of someone recording evidence for a legal proceeding. "I'm documenting this incident," he announced, "along with the time, duration, and circumstances. The Willowbrook Meadows HOA has clear noise ordinances, and continued violations will result in formal complaints and potential legal action." That's when I realized Derek wasn't just a difficult neighbor who needed time to adjust to living next to a dog. He was someone who planned to escalate every minor disagreement into a formal dispute, using HOA regulations as weapons rather than guidelines for community harmony. My 15 years of experience in property law had taught me to recognize the personality type that views legal procedures as tools for controlling other people rather than resolving conflicts fairly. Over the following weeks, Derek's surveillance of my property became systematic and invasive. He positioned himself at his front window during Copper's morning and evening walk times, taking notes on a clipboard whenever my dog made any sound at all. He installed what appeared to be a security camera pointing directly at my front yard, and he began approaching other neighbors with complaints about the noise situation that was supposedly affecting the entire community's quality of life. The most disturbing aspect of Derek's campaign was how he began misrepresenting normal dog behavior as evidence of chronic noise violations. When Copper briefly barked at a garbage truck on Tuesday morning, Derek logged it as sustained aggressive barking, lasting several minutes. When Copper greeted me with a happy bark when I returned from grocery shopping on Thursday afternoon, Derek recorded it as unprovoked noise disturbance during quiet hours. He was creating a documented narrative that bore no resemblance to reality, but would look impressive to anyone who wasn't actually witnessing the incidents he described. The situation escalated when Derek somehow got himself appointed to the HOA board during their April meeting. The previous board member, Tom Rodriguez, had moved away the month before, leaving a vacancy that Derek volunteered to fill, since no one else expressed interest in the position, and Derek presented himself as someone with relevant experience in regulatory compliance. The other board members accepted his appointment without much discussion. Derek's first official act as an HOA board member was to propose what he called enhanced noise ordinance enforcement procedures during the May board meeting. According to the meeting minutes that were distributed to all residents, the new procedures would include detailed documentation requirements for noise complaints, escalating penalties for repeated violations, and expedited legal action for residents who failed to address legitimate community concerns. When I read through the proposed changes, my legal training immediately flagged several problems with Derek's language and approach. The proposed ordinances were vaguely worded in ways that would make them difficult to enforce fairly, and the penalty structure was disproportionately harsh for the types of minor disturbances that occur in any residential community. More concerning was the lack of due process, protections, or appeals procedures, suggesting that Derek was more interested in creating tools for harassment than establishing reasonable community standards. I decided to attend the June HOA meeting to address these concerns directly with the board and other residents. The meeting was held in the community center, a converted double-wide trailer that served as headquarters for neighborhood functions and HOA business. When I arrived with Copper on his leash, planning to demonstrate his well-behaved nature, Derek immediately objected to the presence of animals at official HOA meetings. This is exactly the kind of disregard for community standards that we're trying to address. Derek announced to the dozen residents in attendance, "Bringing an animal to an official meeting shows a fundamental lack of respect for appropriate conduct and other residents' comfort levels." I pointed out that there was nothing in the HOA bylaws prohibiting well-behaved pets at community meetings, and that Copper was quieter and better behaved than most of the human attendees. But Derek had already established the narrative that I was someone who refused to follow reasonable rules, and several residents who didn't know me personally seemed to accept his characterization without question. During the discussion of the proposed noise ordinances, I raised specific concerns about the vague language and harsh penalties, drawing on my professional experience to explain why such regulations would be difficult to enforce fairly and might create more problems than they solved. Derek's response was to dismiss my concerns as self-serving complaints from someone who was already violating existing community standards and was trying to avoid accountability for her actions. The most disturbing moment came when Derek pulled out a thick folder of documentation that he claimed represented a comprehensive record of noise violations from my property over the previous 2 months. He read aloud from incident reports, describing sustained barking episodes, aggressive animal behavior, and disruption of neighbors' peaceful enjoyment of their homes. The descriptions bore no resemblance to Copper's actual behavior, but they sounded impressive and concerning to residents who hadn't witnessed the incidents firsthand. When I challenged the accuracy of Derek's reports and offered to provide witness testimony from neighbors who had actually observed Copper's behavior, Derek accused me of attempting to intimidate witnesses and interfere with legitimate HOA enforcement procedures. He suggested that my legal background was making me believe I was above community standards that applied to everyone else. The meeting ended with the board voting to approve Derek's enhanced noise ordinance procedures, with implementation beginning immediately. I was informed that I would receive official notice of any future violations and would be expected to respond according to the new procedures. Derek had successfully transformed a minor neighbor dispute into a formal legal framework that positioned him as the enforcer and me as the perpetual violator. Walking home that evening with Copper trotting peacefully beside me, I realized that Derek's campaign was about much more than noise complaints or community standards. He was someone who had found a position of authority and was using it to settle personal grievances and demonstrate power over neighbors he didn't like. The HOA regulations were just tools for harassment disguised as legitimate governance. The formal violation notice arrived the following Tuesday, delivered by certified mail in an official-looking envelope with Willowbrook Meadows HOA enforcement action printed in bold letters across the top. The letter was 2 pages long, written in language that attempted to sound legal and authoritative while describing Copper's behavior in terms that made him sound like a dangerous public nuisance. According to Derek's documentation, my property had been the source of chronic noise violations totaling 37 separate incidents over the previous month. Each incident was described with specific times, dates, and duration estimates that suggested Derek had been conducting professional surveillance of my daily routine. The letter demanded immediate action to address the violations and warned that continued non-compliance would result in escalating penalties, including potential legal action and forced removal of the animal causing the disturbances. Reading through Derek's incident reports with my professional eye for detail, I noticed several things that suggested his documentation was less objective than he claimed. Many of the reported incidents occurred at times when I knew Copper had been inside the house, and the described duration of barking episodes was consistently exaggerated compared to what actually happened. Most tellingly, Derek's reports included detailed descriptions of Copper's emotional state and motivations that would be impossible to determine through casual observation. The letter concluded with a demand for a written response within 10 business days, along with a detailed plan for addressing the noise violations and preventing future incidents. The penalty for non-compliance was listed as $500 for the first violation, $000 for the second violation, and potential legal action for any subsequent problems. I spent that evening researching the legal authority for HOA noise ordinances and the procedures required for legitimate enforcement actions. What I discovered was that Derek's approach violated several basic principles of due process and fair enforcement. The ordinances he was citing had been created without proper notice to residents. The penalty structure was disproportionate to the alleged violations, and there was no appeals process or independent review of his enforcement decisions. More importantly, I found that Colorado state law required HOA enforcement actions to meet specific procedural requirements that Derek was completely ignoring. Legitimate noise ordinance violations required objective measurement of decibel levels, independent verification of complaints, and opportunities for residents to address problems before penalties were imposed. Derek's subjective observations and personal documentation didn't meet the legal standards for municipal noise violations, and his role as both complainant and enforcement authority created obvious conflicts of interest. My written response to Derek's violation notice was a carefully crafted legal document that challenged both the factual accuracy of his claims and the procedural validity of his enforcement actions. I demanded copies of any objective measurements of noise levels, independent verification of the reported incidents, and detailed information about the legal authority for the ordinances he was attempting to enforce. I also included witness statements from Martha and George Wilson, who had observed Copper's actual behavior during several of the incidents Derek described, and from Sandra Kim, who confirmed that she had never been disturbed by barking from my property, despite living close enough to hear any significant noise disturbances. Derek's response arrived 10 days later, and it revealed that he had no intention of engaging in reasonable dispute resolution or addressing my legitimate legal concerns. Instead of providing the requested documentation or acknowledging any problems with his enforcement procedures, he had escalated the matter to the HOA's attorney with a recommendation for immediate legal action. The letter from Patterson and Associates, representing the Willowbrook Meadows HOA, was a masterpiece of legal intimidation disguised as professional correspondence. The attorney, Michael Patterson, informed me that the HOA was prepared to file a lawsuit seeking $50 in damages for ongoing noise violations, emotional distress to other residents, and diminished property values caused by my refusal to address legitimate community concerns. The lawsuit threat was clearly designed to frighten me into compliance rather than actually resolve any noise issues. The claimed damages were wildly disproportionate to any possible harm caused by occasional dog barking, and the legal theories being proposed had no basis in Colorado nuisance law. Patterson was counting on my lack of legal knowledge and my unwillingness to fight an expensive court battle against the entire HOA. What Patterson and Derek didn't know was that their threat had activated every professional instinct I'd developed during 15 years of paralegal work. I recognized their strategy because I'd seen similar intimidation tactics used by attorneys who were more interested in generating fees than achieving fair resolutions. Their letter contained several legal errors and procedural mistakes that suggested they were either incompetent or deliberately misrepresenting the strength of their case. The most interesting discovery came when I researched Patterson and Associates and found that Michael Patterson had been representing Willowbrook Meadows HOA for less than 6 months. taking over from the previous attorney who had resigned for undisclosed reasons. Patterson's fee structure was based on hourly billing rather than flat rates for routine HOA business, giving him a financial incentive to escalate disputes rather than resolve them efficiently. I also found that Patterson had been involved in several similar cases involving aggressive HOA enforcement actions that had ultimately been dismissed or settled for nominal amounts after courts found the enforcement procedures to be procedurally defective. He appeared to specialize in taking money from HOAs for legal actions that were unlikely to succeed but would generate substantial attorney fees before being resolved. The formal lawsuit was filed 3 weeks later, and reading through the complaint confirmed my suspicions about the quality of legal work Patterson was providing. The case was full of factual errors, legal misstatements, and procedural deficiencies that would make it easy to defend if I chose to fight rather than settle. The complaint alleged that Copper's barking constituted a private nuisance that had caused substantial interference with other residents' use and enjoyment of their properties. It claimed that my refusal to address the problem, despite repeated warnings, had forced the HOA to seek judicial intervention to protect the community's rights and property values. The damages sought included $30,000 for alleged diminishment of property values, HOA 000 for emotional distress to affected residents, and $5,000 in attorney fees and costs. The complaint also sought injunctive relief requiring me to remove Copper from the property or take unspecified measures to eliminate all barking. What made the lawsuit particularly offensive was how it misrepresented both the facts and the law. The complaint described Copper as engaging in frequent, loud, and sustained barking episodes that had terrorized the neighborhood and created an atmosphere of fear and distress among peaceful residents. Anyone who had actually met Copper would recognize these descriptions as absurd fabrications designed to make a gentle rescue dog sound like a dangerous menace. I had 30 days to file an answer to the complaint, and I used that time to conduct the kind of thorough investigation that Patterson should have done before filing his lawsuit. What I discovered was that Derek and Patterson had built their case on a foundation of lies, procedural violations, and outright fraud that was about to collapse under the weight of actual evidence. My first step was to interview every resident who had allegedly been affected by Copper's barking, according to the lawsuit's claims. This required going door to door throughout Willowbrook Meadows, with a legal pad and a list of specific questions about their actual experiences versus what Derek had documented in his incident reports. The results were revelatory. Of the 12 residents Derek claimed had complained about Copper's barking, 8 told me they had never spoken to Derek about noise issues and were surprised to learn their names appeared in HOA documentation. 3 others said Derek had approached them with leading questions about neighborhood noise, but they had never specifically complained about my dog or requested any enforcement action. Most damaging to Derek's credibility was the discovery that several of his most serious incident reports described barking episodes that had allegedly occurred when Copper was not even on the property. I found veterinary records, boarding receipts, and witness testimony proving that Copper had been at the emergency vet clinic during one reported incident, staying overnight at a professional boarding facility during another, and traveling with me to visit my sister in Denver during a third. The evidence suggested that Derek had been falsifying incident reports to build a case that would justify legal action, regardless of whether actual noise violations had occurred. He had created a fictional narrative of chronic disturbances and community complaints that bore no relationship to reality. My investigation also revealed problems with Derek's appointment to the HOA board that called into question his authority to initiate enforcement actions. According to the HOA bylaws, board vacancies were supposed to be filled through a formal nomination and voting process that included notice to all residents and an opportunity for multiple candidates to apply. Derek's appointment had bypassed these procedures, making his position potentially invalid and his enforcement actions unauthorized. More significantly, I discovered that the enhanced noise ordinance procedures Derek had used to justify his lawsuit had never been properly adopted, according to the HOA's governing documents. Changes to enforcement procedures required approval by a majority of all homeowners, not just board members, and must be preceded by written notice and a comment period. Derek had implemented his new procedures without following any of these requirements, making them unenforceable. The most shocking discovery came when I found evidence that Michael Patterson had never properly investigated the claims before filing the lawsuit. My records request to Patterson's office revealed that his entire case was based on Derek's documentation, with no independent verification or legal research into the validity of the underlying claims. Patterson had charged the HOA over $8 in legal fees for work that consisted primarily of copying Derek's incident reports into legal language and filing a complaint that any first-year law student could have prepared in a few hours. He had billed additional hours for case investigation and witness interviews that had never actually occurred. Armed with evidence of Derek's fraud and Patterson's negligence, I filed a motion to dismiss the lawsuit, along with a countersuit alleging malicious prosecution, abuse of process, and violation of my civil rights under Colorado's homeowner protection statutes. My motion included sworn affidavits from witnesses who could testify about Derek's false statements, documentary evidence proving his incident reports were fabricated, and legal analysis demonstrating that the HOA's enforcement procedures were procedurally defective. The motion also included a detailed breakdown of Patterson's billing practices and a request for sanctions against both him and Derek for filing a frivolous lawsuit based on knowingly false information. I was asking the court to dismiss their case with prejudice, award me attorney fees, and refer both Derek and Patterson to appropriate disciplinary authorities for their conduct. Derek's response to my motion revealed the depth of his panic as he realized his fraudulent scheme was being exposed. Instead of addressing the factual evidence I had presented, he filed an emergency motion, claiming that I was harassing witnesses and attempting to intimidate him through frivolous legal tactics. His motion included a bizarre claim that my door-to-door interviews with neighbors constituted stalking and witness tampering. Despite the fact that these interviews had uncovered his false statements and documented his misrepresentation of community sentiment, Derek was essentially arguing that investigating the truth should be prohibited because it made his lies impossible to maintain. Patterson's response was even more revealing, as it became clear that he had never bothered to verify Derek's claims before filing the lawsuit. When confronted with evidence that many of Derek's incident reports were fabricated, Patterson claimed he had relied on his client's representations in good faith and should not be held responsible for any inaccuracies in the underlying documentation. This response contradicted Patterson's own billing records, which showed he had charged for investigation and verification work that had never been performed. He had essentially admitted to billing fraud while trying to avoid responsibility for filing a meritless lawsuit. The hearing on my motion to dismiss was scheduled for a Tuesday morning in late August, and I arrived at the courthouse prepared for what I expected to be a routine presentation of evidence that would quickly resolve the case in my favor. What I didn't expect was that Derek would make one final desperate attempt to salvage his position by presenting new evidence that would backfire spectacularly. Judge Margaret Foster was a 15-year veteran of the county court system, with a reputation for efficiency and low tolerance for legal nonsense. She had reviewed my motion and supporting documentation before the hearing, and her questions to Patterson made it clear she was skeptical about the strength of his case. "Mr. Patterson," Judge Foster began, "I've reviewed the plaintiff's incident reports and the defendant's evidence suggesting these reports contain factual inaccuracies. Can you explain how your client documented barking incidents that allegedly occurred when the dog was not on the property?" Patterson's response was a masterclass in evasion and deflection. He claimed that the exact timing of specific incidents was less important than the overall pattern of disturbances, and that minor discrepancies in documentation didn't invalidate the community's legitimate concerns about noise violations. Judge Foster was not impressed. "Mr. Patterson, these aren't minor discrepancies. The defendant has provided veterinary records showing her dog was receiving emergency medical care during one of your client's reported incidents. How do you reconcile this evidence with your claims?" That's when Derek, apparently believing he could salvage the situation through additional deception, approached the bench with what he claimed was newly discovered evidence that would prove his case conclusively. He presented Judge Foster with what appeared to be a professional audio recording that he claimed captured Copper's barking during one of the alleged violations. Derek explained that he had installed sophisticated recording equipment to document the noise disturbances objectively, and that this recording would prove the severity and duration of the barking episodes that were disturbing the community. He played a portion of the recording that featured loud, sustained barking that did sound disturbing and excessive. Judge Foster listened to the recording with obvious interest, then asked Derek several detailed questions about when and how it had been made. Derek's answers were confident and specific, providing exact dates, times, and technical details about his recording setup. That's when I realized Derek had just made the mistake that would destroy any remaining credibility and expose the full extent of his fraudulent scheme. I requested permission to cross-examine Derek about his recording, and Judge Foster granted my request with obvious curiosity about where this was heading. "Mr. Hoffman," I began, "you've testified that this recording was made on the 15th of June at approximately 3:30 p.m., using equipment you installed specifically to document noise violations from my property. Is that correct?" Derek confirmed his testimony with the confidence of someone who believed he had finally produced the evidence that would vindicate his entire campaign. "And you're certain about the date and time?" I asked. Derek nodded emphatically. "Your Honor," I said, approaching the bench with my own folder of documents, "I'd like to present evidence that Mr. Hoffman's recording is fraudulent and was created using audio from a different source entirely." I handed Judge Foster a series of documents that I had prepared after analyzing Derek's recording using audio forensic software. The recording contained background noise and acoustic characteristics that were inconsistent with outdoor recording in our neighborhood, and the barking pattern matched a commercially available sound effect that could be purchased online for use in film and television production. More importantly, I had definitive proof that Derek's recording could not have been made when and where he claimed. On the 15th of June, at 3:30 p.m., I had been at my sister's house in Denver with Copper, visiting for her birthday party. I had photographs, credit card receipts, and witness testimony proving that Copper was 60 miles away from Willowbrook Meadows when Derek claimed to have recorded him barking in my backyard. The courtroom fell silent as Judge Foster reviewed the evidence and realized the implications of what Derek had just attempted. He had not only committed fraud by presenting falsified evidence, but he had committed perjury by lying under oath about how and when the recording was made. Judge Foster's response was swift and severe. She immediately dismissed the HOA's lawsuit with prejudice, meaning it could never be refiled, and ordered Derek and Patterson to show cause why they should not be held in contempt of court for presenting fraudulent evidence. She also referred the matter to the district attorney's office for potential criminal prosecution and to the Colorado Bar Association for disciplinary action against Patterson. The sanctions hearing that followed 2 weeks later resulted in Derek being ordered to pay $15,000 in attorney fees and court costs, plus an additional $5,000 fine for contempt of court. Patterson received a formal reprimand from the Bar Association and was required to repay the HOA for all legal fees he had charged in connection with the fraudulent lawsuit. More satisfying than the financial penalties was watching Derek's carefully constructed facade of authority and respectability crumble completely as the full scope of his deception became public knowledge. The local newspaper covered the story under the headline, "HOA board member convicted of filing fraudulent lawsuit against neighbor's dog," and Derek's fraudulent audio recording became a cautionary tale about the consequences of lying under oath. The aftermath of the court case brought changes to Willowbrook Meadows that went far beyond resolving my specific dispute with Derek. The revelation that an HOA board member had been fabricating violations and misusing community resources to pursue personal vendettas prompted a complete review of the association's governance and enforcement procedures. Derek resigned from the HOA board in disgrace and put his house on the market within a month of the sanctions hearing. He moved away without saying goodbye to any neighbors, leaving behind a reputation as someone who had betrayed the trust of an entire community through his lies and abuse of authority. The new HOA board, elected after Derek's departure, implemented transparency measures and due process protections that ensured no future resident could be subjected to the kind of harassment I had experienced. They also hired a new attorney who charged reasonable flat fees for routine HOA business rather than billable hours that incentivized unnecessary legal action. Most importantly, the experience brought the Willowbrook Meadows community closer together as neighbors realized how Derek's divisive tactics had been undermining the sense of trust and cooperation that made the neighborhood special. The residents who had been misled by Derek's false claims about community complaints apologized and became some of Copper's strongest supporters. 6 months later, I was elected to serve on the HOA board myself, bringing my legal experience to help ensure that future disputes would be resolved fairly and that no resident would ever again be victimized by someone abusing positions of authority for personal revenge. Copper became something of a neighborhood celebrity, known for his gentle nature and his role in exposing HOA corruption. The story of Derek's fraudulent lawsuit became a cautionary tale that was shared in legal circles as an example of what happens when procedural safeguards are ignored and authority is abused. My case was cited in several law review articles about HOA governance and the importance of due process protections in community enforcement actions. Looking back on the experience, I'm grateful that Derek's harassment forced me to use my legal skills in defense of my rights and my community's integrity. His attempts to intimidate me into giving up Copper led to the discovery of systematic fraud that was harming the entire neighborhood. Sometimes the best way to deal with a bully is to expose their lies and hold them accountable for the consequences of their actions. Today, Copper and I still live peacefully at 1,247 Maple Lane, surrounded by neighbors who understand that a well-trained dog's occasional barking is part of normal community life. The house across the street is now occupied by a family with 2 young children who love playing with Copper in the backyard and have never once complained about noise. It's amazing how much quieter a neighborhood can become when you remove the people who are deliberately trying to create conflict and division. The lesson here isn't just about standing up to HOA bullies or fighting fraudulent lawsuits. It's about the importance of truth, accountability, and the rule of law in protecting ordinary people from those who would abuse positions of authority for personal gain. When someone tries to use fake documentation and procedural manipulation to control your life, sometimes the best response is to demand real evidence and hold them to the standards they claim to represent. The ripple effects of Derek's exposure extended far beyond Willowbrook Meadows, creating a precedent that would help HOA victims across Colorado and neighboring states. 3 months after the court case concluded, I received a call from Jennifer Martinez, a paralegal working for the Colorado Attorney General's office, asking if I would be willing to consult on a statewide investigation into HOA fraud and abuse. The investigation had been triggered by my case. But as Jennifer explained, Derek's tactics were part of a much larger pattern of HOA corruption that had been flying under the radar for years. Small-scale fraud, procedural violations, and abuse of authority were endemic in communities across the state. But most victims either didn't know their rights or couldn't afford to fight back against well-funded HOA legal teams. My experience had demonstrated that these cases could be won when someone with legal knowledge was willing to dig into the details and expose the lies, but most homeowners lacked the resources and expertise to mount effective defenses. The Attorney General's office wanted to develop standardized procedures for investigating HOA complaints and create educational materials to help residents protect themselves from fraudulent enforcement actions. I agreed to serve as a consultant on the project, and over the following months, I reviewed hundreds of cases involving HOA disputes across Colorado. The patterns were depressingly familiar. Board members using their positions to settle personal grudges, attorneys billing excessive fees for unnecessary legal action, and residents being intimidated into compliance through threats of expensive litigation they couldn't afford to defend. The most disturbing cases involved vulnerable populations like elderly residents on fixed incomes and non-English speakers, who were specifically targeted because they were less likely to challenge fraudulent citations or understand their legal rights. Derek's tactics had been relatively sophisticated compared to some of the schemes we uncovered, where HOA boards were simply making up rules and penalties without any pretense of following proper procedures. My work with the Attorney General's office led to the passage of the Colorado HOA Accountability Act, and legislation that established mandatory training for HOA board members, created standardized procedures for enforcement actions, and provided legal remedies for residents who were victims of HOA fraud or abuse. The law also required HOAs to maintain transparent financial records and prohibited attorneys from charging hourly fees for routine enforcement actions. The legislation was signed into law 18 months after my case concluded, and I was invited to attend the signing ceremony as someone whose experience had helped demonstrate the need for these protections. Standing in the state capitol, surrounded by other HOA reform advocates, I thought about how Derek's harassment campaign had ultimately led to legal changes that would protect thousands of homeowners from similar abuse. Back in Willowbrook Meadows, the community had transformed into something much stronger and more cohesive than it had been before Derek's divisive influence. The new HOA board had implemented monthly community meetings where residents could raise concerns and discuss neighborhood issues in an open forum, replacing the secretive and authoritarian approach that had characterized Derek's brief tenure. Copper had become an unofficial mascot for the community, and his presence at HOA meetings was not only welcomed but encouraged as a reminder of how false accusations and manufactured crises could tear apart the trust that made neighborhoods function. Children in the community had adopted him as their unofficial therapy dog, and parents regularly brought their kids to our backyard for informal play sessions that built friendships across age groups and family backgrounds. The house Derek had abandoned was eventually purchased by the Morrison family, a young couple with twin toddlers, who were delighted to discover they would be living across from a friendly dog and his owner, who had become something of a local hero. When they asked me about the neighborhood's history during their move-in process, I gave them the abbreviated version that focused on community resilience, rather than dwelling on the toxic behavior that had temporarily disrupted our peace. My role as an HOA board member evolved into something much more significant than I had anticipated when I first agreed to serve. Word of my successful defense against Derek's lawsuit spread through legal and real estate networks, and I began receiving calls from residents in other communities who were facing similar harassment campaigns from their own HOA boards. I developed a consultation practice that helped homeowners understand their rights and navigate HOA disputes without necessarily having to resort to expensive litigation. Most cases could be resolved simply by demonstrating that the homeowner knew the law and was prepared to hold the HOA accountable for following proper procedures. But occasionally, I encountered situations that required more aggressive intervention. The most satisfying case involved an elderly veteran named Robert Chen, who was being harassed by his HOA for flying an American flag in his front yard. The HOA claimed the flag violated architectural guidelines, but my research revealed that Colorado state law specifically protected residents' rights to display the American flag, regardless of HOA restrictions. One carefully worded letter citing the relevant statutes was enough to end the harassment and result in a formal apology from the HOA board. Derek's ultimate fate served as a cautionary tale about the long-term consequences of fraud and abuse of authority. The criminal charges filed against him for perjury resulted in a conviction and 18 months of probation, but the civil consequences were more severe and lasting. The homeowners he had deceived filed a class action lawsuit against him for the fees and costs they had incurred as a result of his fraudulent enforcement actions, resulting in a judgment that garnished his wages for several years. More significantly, Derek's conviction made him unemployable in his chosen field of pharmaceutical sales, where background checks and professional integrity were essential requirements. He eventually found work in a completely different industry, but at a significantly lower income level that reflected his damaged reputation and limited career options. The professional consequences for Michael Patterson were equally severe, as the Colorado Bar Association's investigation revealed a pattern of billing fraud and inadequate case preparation that extended beyond my lawsuit to several other HOA cases he had handled. His license was suspended for 6 months, and he was required to complete continuing education courses on legal ethics and professional responsibility before being allowed to practice again. When Patterson's suspension became public, several of his former HOA clients discovered they had been overcharged for legal services that were never actually performed, leading to additional disciplinary actions and civil lawsuits that effectively ended his career specializing in HOA law. 3 years after the lawsuit was dismissed, I received a letter from Derek that was forwarded through my attorney's office. It was a brief apology, acknowledging that his behavior had been wrong and expressing hope that I could forgive him for the stress and expense he had caused. The letter seemed genuine rather than strategic, suggesting that the consequences of his actions had given him time to reflect on how his need for control and authority had led him to hurt innocent people. I chose not to respond to Derek's letter, but I kept it as a reminder that even people who cause significant harm are capable of recognizing their mistakes and attempting to make amends. His apology didn't undo the damage he had caused, but it suggested that the legal consequences he faced had served their intended purpose of education and deterrence. Today, Willowbrook Meadows operates as a model HOA community that other neighborhoods study when developing their own governance procedures. We have clear, fair enforcement policy, transparent financial management, and a culture of cooperation rather than conflict. Copper continues to be a beloved member of our community, and his occasional barking is recognized for what it always was: the normal behavior of a well-trained dog who takes his job of protecting his family seriously. The experience taught me that sometimes the best way to protect your own rights is to stand up for principles that protect everyone's rights, and that holding people accountable for fraud and abuse benefits entire communities rather than just individual victims.